The civil procedure question from July of 1997 is another tricky problem. It's tricky because it tests a couple of issues that we are not that accustomed to, and that's why I included it in this seminar. Our work here is basically a greatest hits collection of civil procedure issues. By the time we're done together, you will have had a very comprehensive look at how these issues are tested. Take a look at the call of the question here. We are asked whether or not the federal district court ruled correctly on 1. The plaintiff's first motion to remand the lawsuit to state court. Discuss. Well, stop right there. We've got a plaintiff trying to get a case remanded to state court? Doesn't the plaintiff get to choose the jurisdiction? The first call of the question implies that the defendant has removed the case to federal court. Removal jurisdiction is not very commonly tested. The second call of the question. Did the federal district court rule correctly on the plaintiff's motion to amend the complaint to name Tom as a defendant? Discuss. This implies jurisdiction issues with regard to Tom, and remember, we are in federal court now. 3. Plaintiff's renewed motion to remand the lawsuit to state court. Discuss. Well, we've got two motions to remand discussed in the first and third calls of the question. So we know already that this is a somewhat unconventional question touching on fairly tricky topics. But as it turns out, this is a fact pattern that we can divide and conquer fairly readily. So let's do it. Go to the top of the question and we learn about dangerous fumes that are released by a fire and explosion at an oil refinery owned by the defendant Danco in State A. And we find out about evacuees, all of them residents of State A, filing a civil action in state court in State A against Danco based on state theories. Each plaintiff wants compensatory and punitive damages, and the plaintiff's compensatory damage claims based on the injuries alleged range from $30,000 to $35,000 apiece. And the claims for punitive damages are for amounts to be determined by proof. Well, the only reason they would give us these dollar figures is to give us some idea about the amount in controversy in federal court. And the issue boils down to whether or not a series of plaintiffs can aggregate their claims to a big enough number that would allow for diversity. But remember, we've got a plaintiff who wants to be in state court. In paragraph 2, we learn about the State B corporation with headquarters in State C, and we learn more about Danco's operations here. There's an ongoing regulatory agency review in State A and a possible safety violations by Danco found there. In paragraph 3, our prediction comes true. Danco removes the action from state court to federal district court in State A. The plaintiffs move to remand back to state court based on the fact that Danco's biggest refinery is in State A, and also based on the ongoing regulatory hearing. The federal court denies the motion. Then Danco files its answer in federal court. The plaintiffs then move to file an amended complaint naming Tom a State A contractor, alleging that Tom had built the refinery and that Danco and Tom are jointly and severally liable. The court grants the motion to amend over Danco's objection. Then the plaintiffs renew their motion to remand, and the renewed motion is granted. So that's kind of interesting. We get opposite results in the two motions to remand, and so, interestingly, we get to pay a lot of attention to a somewhat obscure topic, and that's not out of the ordinary for bar exams. Remember, out of any given bar exam, and it's 6 essays here in California, at least one of the essays is going to be somewhat unconventional. 5 or 4 of them will be almost knockoffs of ones you've reviewed with me. But 1 or 2 of them will be somewhat different. And when you see them, you can smile to yourself, knowing that I am likely to incorporate those questions into future seminars. And then, do your best. Organize the issues, apply the facts, follow the basic techniques, and apply them in a somewhat unconventional context. So let's see how I chose to organize an answer to this question. Please turn to my outline of issues. We can see, first, that I start off with Danco's removal of the case to federal court. There's no federal question present, so the defendant's motion to remand has to be based on diversity. I focus on the amount in controversy and diversity of the parties. We've got to find a home for all of those details. And then I touch on the ongoing state regulatory hearing, and my conclusion is a fairly subtle one, a somewhat less clear-cut conclusion than most of the ones that I reach on essays in this course. I conclude that the court's denial of the motion was not an abuse of discretion. It looks to me like quite a close call, but I can't say that the federal court got it wrong on its face. It doesn't look like the court acted in an abusive fashion. We may reasonably disagree with the court, but we can't conclusively argue that the court was wrong. Next, we examine the plaintiff's motion to amend the complaint to add Tom. Here, this request has come after the answer has been filed, and here we get a chance to deal with permissive and necessary joinder. It requires us to analyze the facts with regard to Tom, which is not that complicated a process once we set up our analysis in the appropriate way. Then finally, we examine the plaintiff's renewed motion to remand the case to state court. If Tom is necessary or indispensable, the case has to go to state court. But like many defense lawyers, or as my friends in the plaintiff's bar like to refer to me, like my fellow insurance company scumbags, I look at this situation and I think it's possible the plaintiffs acted in bad faith. So have a look at my analysis and see if you don't agree that I am at least making a reasonably persuasive showing that the issue is worth considering. Obviously, it's not central to the case. Okay, now let's take a look at the answer that I provide and take a look at my analysis. Look at what I do in the very first paragraph on page 1 of the answer. Basically, I lead with the facts in such a way as to set the stage procedurally for what follows. And right up front, I explain what we have to do in order to make a judgment about the court's decision. We have to look at the removal motion and the plaintiff's justification in support of their motion. So we look at Danco's removal. We see that I state the law up front very briefly. I indicate carefully that there's no federal question present, and I think you can see just how clear that is correct. But then we focus on diversity. And here the parties are diverse, and in 3 paragraphs in section 2A, you'll see I find a home for all of the details. I'm not leaving anything to chance. I'm also not leaving anything out. Next, we turn to the amount in controversy requirement, and here it seems to me that some fairly intricate analysis is required. It seems to me here, again, that it is a fairly close call. But I'm willing to aggregate the claims, and given that there could be a substantial punitive damages award on top of compensatory damages, I don't think it's unreasonable to conclude that the amount in controversy requirement has been satisfied. I spent a little bit of time on the ongoing state regulatory hearing, and ultimately, as I indicated earlier, I conclude that it would not be an abuse of discretion for the court to deny the motion. Next, we move to the plaintiff's motion to amend the complaint to add Tom. Here I work in some law where we point out that before a defendant answers, the plaintiff is fairly free to amend. But after an answer, leave of court is required. Here, the court grants that leave over Danco's objection. It's within the court's authority to do so, but we have to analyze the situation to determine that the court was correct or not. I'm concluding that it was not correct. We look at permissive and necessary joinder. Certainly permissive joinder is not going to be allowed here because supplemental jurisdiction doesn't extend to an act by the plaintiff. As we see in other practice questions together, a defendant can implead another defendant that would otherwise destroy diversity in order to litigate an indemnification claim, and that does not offend diversity jurisdiction. But when a plaintiff seeks to do so, that does ruin diversity, and so I conclude that the court was wrong to grant the plaintiff's motion to amend if the court decided that Tom was really important and that it wasn't really possible to proceed without him. Then what the court should have done is just kick the case down to state court. Finally, we look at the plaintiff's renewed motion to remand the case to state court, and here again, we touch on Tom. If Tom is a necessary or indispensable party, really the federal court doesn't have jurisdiction over the case because diversity is lacking. But the question that comes to my mind is, how come the plaintiffs didn't name Tom as a defendant in the first place? The facts are silent as to that, and perhaps it is reasonable to conclude that they didn't know about Tom until they discovered him in the discovery process in federal litigation. If that's true, then certainly it is necessary to remand, and the court was correct to do so. But if the plaintiffs are really forum shopping here, if they are jerking the system in order to try to get a result that they want, that should be prohibited. So I think we could reasonably conclude either way. But I suggest the mainstream approach, probably the quote-unquote correct answer, is that the court was correct when it granted the plaintiffs' renewed motion to remand this case to state court.